May it please the Court. My name is Jack Durham, and along with my co-counsel Alexis Phan, we represent the Respondent, the United States of America, in today's case. I will be addressing two issues before the Court. One, whether or not the United States could have had his location under the Stored Communication Act, and two, whether there was a search or seizure in today's case. The Stored Communication Act states that a court order to disclose under subsection B or C may be issued to any court that is a court of competent jurisdiction and shall be issued if the government entity offers specific and articulable facts showing that there are reasonable grounds to believe that the contents of a wire or electrical communication or the records or other information sought are relevant or material to an ongoing criminal investigation.
Counselor, is this test of reasonable grounds substantially similar to probable cause that's required by the Fourth Amendment, or are these different standards?
Can you please repeat your question, Your Honor?
Yes. Is reasonable grounds, which the Stored Communications Act requires, a different standard than the probable cause required by the Fourth Amendment, or are they substantially the same?
I think they are different in a way, because I think they are different. Yes, Your Honor.
Okay. So is the Stored Communications Act a way for Congress to bypass the needs of the Fourth Amendment? Or what was the purpose of the act?
It is to help police forces to get the information, electrical communications of persons.
Okay, so absent the Stored Communications Act, would people have no expectation of privacy in their personal records, or some expectation of privacy?
They would still have an expectation of privacy, Your Honor.
Okay.
In an application, an application to Carpenter, the FBI applied to magistrate judges for permission to obtain transactional records that provide evidence that Carpenter and others had violated the Hobbs Act. The magistrate judges later granted the application under the Stored Communication Act. The application was granted by magistrate judges from a court of competent jurisdiction. The FBI showed specific and articulable facts from one of the members in the armed robberies and gave the numbers of the other accomplices.
Counselor, is the verbal testimony of one suspect enough to qualify for probable cause to search a private cell phone data?
Yes, Your Honor, I think so, because he willingly gave over his information and the information of others, Your Honor.
Okay.
And there were reasonable grounds to believe that the location data was relevant to find out Mr. Carpenter's location during the robberies. Also, in the reapplication of the United States for historical cell site data, it was held that the court's orders under the Stored Communication Act compelling that cell phone service providers to disclose historical cell site information is constitutional, displaying that the obtaining of cell site location data by the government is constitutional. In summary, law enforcement are able to obtain the court's permission to certain records and information without violating the Fourth Amendment, because under the Stored Communication Act, it is justifiable reason to get Mr. Carpenter's location. Katz v. United States established the test to determine if a person has a reasonable expectation of privacy, whether a person could claim Fourth Amendment protections from the government's actions had violated his or her reasonable expectation of privacy and the object of the search or the area from which the item was seized. The first prong of the test is had an actual expectation of privacy. The second prong is that the expectation of privacy is one that society is prepared to recognize as reasonable. For example, the police are not allowed to eavesdrop on a cell phone call, which happened in Katz v. the United States without a warrant.
So, Counselor, given that most people don't know that their cell phone is tracking them at all times, does that make it more or less likely that Mr. Carpenter in this case had an actual expectation of privacy?
The Pew Research Center says that 74% of Americans use location-based data services in their day-to-day lives. So I would think this would be given a common fact. It is reasonable that most people are aware that their cell phones are constantly recording their cell phone location.
Yes, but I think the location data services that you're citing deal with GPS. And there's a section in my settings where I can turn off location data. that doesn't turn off cell site location information at all. So while I might think, oh, my location data is turned off, now I can go rob a bank and my cell phone company can't track me anymore, my cell site location data will still be on. So does it matter that it's GPS versus cell site location data information? Does that change the constitutional issue?
No, but James Madison once said, "Knowledge will forever govern ignorance, and people who mean to be their own governors must arm themselves with the power which knowledge gives." So I think that people, if they wanted to have the knowledge of if they were being located, they would arm themselves with that knowledge, Your Honor.
Okay, so that knowledge is readily available to them, even if people are ignorant of it.
Yes.
Okay.
Even if the petitioner somehow shows that he had a reasonable expectation of privacy, the subject of the expectation was not due to the Fourth Amendment protection. The Fourth Amendment states that the right of the people to be secured in their persons, houses, papers, and effects. The Fourth Amendment protects some privacy interests, allowing individuals to challenge, among other things, the government's recording of conversations in phone booths, just like in Katz versus the United States. The data the police got off the petitioner's phone was his inexact location, which is not a person or a house. The location data they got is not a paper, because a paper is a legal document or where ideas are written and expressed. It is also not an effect, because an effect is an item or property. Location data is not an item in which a reasonable person would have a reasonable expectation of privacy. The cell phone itself is property, but the information such as location and cell phone numbers dialed is not private property, because as stated by the Yale Law Journal, the factors that determine an individual's rights to keep objects free from interference are best unclear and at worst incoherent. A government's rights to keep a person's rights to keep objects free from the government search or seizure is an undefined line. To address the second point of the test in Katz, which is society is prepared to recognize as reasonable, according to the Pew Research Center, 74% of Americans use location-based data services in their day-to-day lives. Given this common fact, it is reasonable to conclude that most people are aware that their cell phones are constantly recording their location data.
Well, and isn't the Stored Communications Act an expression of what Congress thinks is a reasonable expectation? The Stored Communications Act allows police to obtain tracking data over up to 180 days. Doesn't that seem like that's what society is prepared to see as reasonable?
Can you please repeat the question, Your Honor?
Well, the Stored Communications Act itself
Yes.
sets the requirement that as long as police or FBI or law enforcement satisfies these particular things, they can get up to 180 days of cell phone site location data. Doesn't that help your argument that that's an expression by Congress of what they think society thinks is reasonable?
Yes, Your Honor.
Okay.
Because, like you were saying, like if they meet all the requirements showing that there is probable cause or there is reason to suspect something, and they also have to apply to a magistrate judge, which also applies to another person's mind to it.
Okay, so does the magistrate judge requirement of the Stored Communications Act fulfill the same interests that the warrant requirement of the Fourth Amendment fulfills, going to a neutral magistrate? Does the Stored Communications Act, even though it's not called a warrant, fulfill the warrant requirement of the Fourth Amendment?
I don't know. I know that in the Fourth Amendment, as far as I know from my very somewhat limited knowledge of the Fourth Amendment, you have the police go to a judge and go to apply for a warrant, which is kind of what I see as the same thing in this case, that they went to go apply to a magistrate judge in this case.
So you would characterize the Stored Communications Act not as a way to bypass the Fourth Amendment, but as a specific mechanism to fulfill the Fourth Amendment?
Yes, Your Honor.
Okay.
Another question before the court is whether or not there was a search in today's case. The Fourth Amendment the FBI did not search Carpenter at all, because under the third party doctrine, he willingly gave his information over to the third party. The FBI received his information from the third party, not from Carpenter, so he was never searched. In this case, the court does not see this as sufficient proof that the United States did not violate the petitioner's rights. The Stores Communication Act allows the FBI to obtain the location data, meaning that the search and seizure for the location was justified. In summary, that under the Stores Communication Act, the United States was justified with obtaining Mr. Carpenter's location, and that there is no search and seizure. But if the court sees that there was a search and seizure, it is still justified under the Stores Communication Act because the information the FBI obtained was relevant to an ongoing criminal investigation. I will now pass my argument on to my co-counsel, Alexis Phan. Thank you, Your Honor.
Thank you, counsel.
May it please the court, my name is Alexis Phan, and I represent the respondent, the United States of America, in today's case. Today I will be addressing that there is no expectation of privacy by making 2 points. 1. By applying Katz v. United States, there is no expectation of privacy. And 2. That the case law that petitioner relies on to prove there is an expectation of privacy should not be held persuasive to this court. According to the U.S. Constitution's Fourth Amendment, Bill of Rights as proposed, Massachusetts Declaration of Rights, and New York Ratification Convention debates and proceedings, the people will be protected from unreasonable searches and seizures. When analyzing whether there is an expectation of privacy, we apply the subjective and objective expectations of privacy tests in Katz v. United States, the third-party doctrine, Smith v. Maryland, United States v. Miller, and United States v. Graham. In Katz v. United States, federal agents used an eavesdropping device to a public phone booth that Katz used. These conversations were used as evidence to implicate Katz in the transmission of gambling information. The Supreme Court ruled that a physical intrusion into the area that Katz occupied was unnecessary to bring the amendment into play. In a concurring opinion by Justice Harlan in Katz v. United States, the Fourth Amendment prohibits searches where 1. The parties have exhibited a subjective expectation of privacy, and 2. That the expectation must be one that society is prepared to recognize as reasonable, otherwise known as an objective expectation of privacy. This test is later adopted by the Supreme Court. Although there was no physical intrusion, the location data is not covered under Fourth Amendment protections because Carpenter didn't have an actual expectation of privacy. Under Katz, for the Fourth Amendment to be able to prohibit searches, Carpenter and the phone company must have exhibited a subjective expectation of privacy, and that the expectation must be one that society is prepared to recognize as reasonable, or otherwise known as an objective expectation of privacy. As said in the Washington Post article, most cases don't apply a subjective expectation test, but if the court were to apply the standard, along with Smith v. Maryland, where it was held that an expectation of privacy doesn't apply when a person voluntarily turns information over to third parties that is used in the regular conduct of their business. The third-party doctrine that when people voluntarily give information to third parties, such as banks, phone companies, internet service providers, and email servers, they have no reasonable expectation of privacy.
But, Counselor, it sounds like your definition of the third-party doctrine is grounded in voluntariness. And cell phone site location data is taken not only when I make a call or send a text, which I concede would be voluntary, but also when I receive a call or receive a text. Isn't that less voluntary?
No, Your Honor, because, as according to James Madison, knowledge will forever govern ignorance, and the people who mean to be their own governors must arm themselves with the power which knowledge gives. So, in conclusion, the people have access to such information, and it is their own voluntary. They can always find out this knowledge.
Okay, so if Carpenter didn't want to be subject to ongoing search, he would have to not use a cell phone? Does everybody that uses a cell phone volunteer to be subject to ongoing police surveillance?
It is not necessarily ongoing police surveillance because the third party could does not necessarily have to give the information over to police.
Okay, so we already have this protecting mechanism under the Stored Communications Act, and that's sufficient under the Fourth Amendment analysis?
Yes, Your Honor.
Okay.
And so to continue on, under United States v. Miller, a person does not have a reasonable expectation of privacy concerning information found in business transaction records, usually conducted through a third party. Then it should be expected by anyone that uses location data that it is being transmitted through a separate third party, such as wireless carriers. This fails the subjective expectation of privacy.
And these weren't even records that Carpenter had and gave to the wireless carrier. Isn't it the wireless carrier that's making these records to begin with? So isn't it their property and not Carpenter's? Or does Carpenter have a proprietary interest in his location records?
Well, even if Carpenter had an interest in his location records, his use of the cell phone company gave him voluntary consent to give it over to the third party.
And that consent, whether or not he was knowledgeable of it, came about because of his business relationship with the wireless carrier, any contract that he might have signed?
Yes, Your Honor.
Okay.
And so to continue on, for an objective, reasonable expectation of privacy, an expectation of privacy must be generally recognized by society. This is further expanded in Rackus v. Illinois by setting a fine line on how an expectation of privacy may be recognized. RAC has ruled that the expectation of privacy must have a source outside the Fourth Amendment, either by reference to concepts of real or personal property law, or to understandings that are recognized and permitted by society. According to the Pew Research Center, 74% of Americans use location-based services in their day-to-day lives. It is perfectly acceptable for Americans to use location-based services, and for these services to be efficient, it is necessary for the location data to go through third parties, such as telephone or wireless companies. The data is often utilized in the modern lifestyle, social media, or GPS. Further, if we were to look at United States v. Miller, that a person does not have a reasonable expectation of privacy in business transactions when the government obtains it from a third party, which in Miller were banks. To draw comparisons between Carpenter and Miller, both deal with an expectation of privacy with transactions between third parties that are necessary for the parties and their use in modern life. With this, the court can conclusively draw that the Fourth Amendment does not protect information commonly utilized in modern life when it is used in a business transaction. If Americans don't want their location data to be shared, they could simply turn off location tracking features, which at least 46% of teens and 35% of adults have done once.
Yeah, they can turn their location tracking features off. That does not turn off the cell site location data information, though. If I turn off my location tracking feature on my phone and I receive a call, it's still pinging a tower, and that company is still keeping my CSLI data. So does that change the voluntariness of CSLI versus GPS?
Not necessarily, because ignorance of such a feature cannot be an excuse, as summarized by James Madison, who said that knowledge will forever govern ignorance, and a people who mean to be their own governments must arm themselves with the power which knowledge gives. So in total, in following Katz versus the United States, there is no expectation of privacy, because there is no subjective or objective expectation of privacy. Also in United States versus Graham, the court ruled that historical cell site location data does not enjoy Fourth Amendment protection, and therefore no probable cause is necessary to release such data. In application with Carpenter, the location data that was obtained does not enjoy Fourth Amendment protections, and thus no probable cause is required to release it. In conclusion, there is no expectation